many sessions in a subject-focused series called Navigating IP. We're excited to run this session for you today. We're hoping you gain valuable insights and in the process also help us to continue, develop, and improve our educational offerings for startups. Before we give you a short breakdown of the program and introduce you to our speaker, we'd like to play our Communitech land acknowledgement.
All right, so it doesn't seem like it's working. I'm just going to give it a read here. Communitech acknowledges that the hub is situated on the Haldimand Tract, land that was granted to the Haudenosaunee of the Six Nations of the Grand River, and is within the traditional territory of the neutral Anishinaabe and Haudenosaunee peoples. As participant in today's event, we are coming together from many different places. We encourage you to learn about and acknowledge the land from which you participate. We will never stop fostering an anti-racist environment to create a place and space where everyone is free to be their whole selves. Our commitment to building a community rooted in inclusion and equity will never waver, and it will mean listening and learning as we go. Everyone on our team and within our community receives the same respect and opportunity, regardless of age, ethnicity, gender, culture, identity, beliefs, or language.
All right, I'd like to encourage everyone to take a moment to reflect on the land beneath you, acknowledge its Indigenous history, let this awareness inspire a commitment to respect, understand, and preserve the rich heritage of this place we call home. So just a quick breakdown of Elevate IP. Elevate IP is a federally funded program designed to help Canadian startups understand, manage, and leverage their intellectual property. Communitech, along with our partners North Forge and Invest Ottawa, deliver Elevate IP services and support to startups in Ontario, Manitoba, and Saskatchewan. So eligibility for startups here, they must be headquartered in one of the three provinces. They must be CCPC, have less than 500 employees, and the IP protections to be acquired must be owned by the startup and not the individual. So there's three types of tiers within our Elevate IP program. The first is awareness and education, which you are taking part in today. So this is for startups that may be new to IP and give them foundational knowledge for early stage startups. It also provides you with informational resources, workshops, and programs to help you understand the use and competitiveness of IP. Then we have developing IP strategies. So this is for startups in need of an IP strategy where they're connected with a service provider or an IP expert who then provides them with coaching and information to help them access resources required to develop a sound strategy. And lastly, we have implementing IP strategies. So this is for startups with implementation-ready IP work. The startup is, once again, connected with an IP service provider who will then take the necessary steps to protect their IP and will enable them to achieve their business goals. So just some post-session information here. We will be sending out an email with a feedback survey, so please do take a few minutes to complete this. This would be super useful for us to ensure that the content of these sessions moving forward meet the needs of startups as well. And for more Elevate IP updates, please register a profile on the Elevate IP portal. And this will provide you with free access to all of our Tier 1 offerings, and you can also apply for Tier 2 or Tier 3 on there. So to introduce you to our speaker now, David Schnurr is a partner at Miller Thomson LLP, a prominent national firm in Canada, specializing in IP and technology law. He leads the national MTech startup team at the firm, providing legal guidance and mentoring to startups and early-stage businesses. With expertise as a registered patent and trademark agent, he offers a range of services, including patent and trademark prosecution, IP portfolio management, IP due diligence, and enforcement of IP rights. Additionally, he advises on Canada's anti-spam laws and AI regulation. David has extensive experience in technology outsourcing, procurement, and commercial technology agreements. He is also a professor at Western University Faculty of Law, teaching advanced intellectual property, and has authored a chapter on cloud computing in LexisNexis's social media and internet law textbook. David is recognized as a fellow of the Intellectual Property Institute of Canada. And David is also one of our signed IP service providers in the Elevate IP roster of service providers that you may choose to work with if you apply for Tier 2 or Tier 3 in Southwest Ontario. So just to note that the slides will be available after the session. We are also currently recording the session. David is happy to take questions as they come. If you want to unmute or put them in the chat, we will monitor that. And then there will also likely be a short question and answer section at the end of the session. So now over to you, David. Thanks so much.
Thanks, Rochelle. Hi, everybody. Welcome. Firstly, I'm happy to be here. And as Rochelle stated, I'm happy to answer any questions you have throughout the presentation, at the end of the presentation, and certainly offline. If you have any one-off questions you want to get in touch, by all means, feel free to reach out. So we have a great topic today, IP commercialization and licensing. Those two issues certainly go hand in hand. And at their core, you know, we want to help you and emphasize for you that protection strategies go hand in hand with commercialization strategies. So a strong protection framework, a strong protection strategy will no doubt enhance your business's, you know, commercialization prospects, your ability to properly and positively commercialize your IP. So just briefly, I am a registered Canadian and US patent and trademark agent. I do prosecute patent applications in both countries. This can be typically is a more cost-effective process than engaging with US counsel on US patent matters, for example. And if I could plug my firm for a second here. So we are a national full-service law firm. We have offices in most provinces across the country, including 4 offices in Ontario. And because we're full service, we really do offer one-stop shopping. We can manage your IP matters, of course, but we can also assist you with other matters, ancillary matters, you know, corporate matters, incorporation of your business, organizational matters, shareholders agreements, employment matters, litigation, what have you. Also, as an approved Elevate IP service provider, we offer a number of pro bono services to startups, and we can certainly assist you and do assist clients regularly with the Elevate IP and other government funding grant applications and other related processes. So with that said, I'm going to jump into the materials here for today's seminar. We have sort of 3 key topics. We're going to look at IP commercialization best practices generally. The lens here is IP protection.
Sorry, David, just to interrupt you quickly, can you share your slides, please?
Oh, you don't have the slides? Okay, I thought. Sorry about that.
You'll have to share them on your end there.
Okay, how's that?
Perfect, thank you.
Perfect. Okay, sorry about that. So I guess I'm at the 3rd slide here. So yes, as I mentioned, we're going to look at IP commercialization practices. The lens is IP protection. So we're going to look at how you can effectively use IP protection strategies to put yourself in the best position to successfully commercialize your IP, your products or services. We will look at IP as a value generator for your business. including a discussion of some of the key benefits of protecting your IP, and how your protection strategies can help raise the value of your company, including by enhancing revenues. And then related to points 1 and 2 above, we'll be looking at IP licensing. And of course, in certain instances, it may make sense, as we will discuss, to license your IP as a means to grow your business. One final point I'd make on this slide is, we could spend an hour or more talking about any one of these topics. The goal of this seminar is to help you get your feet wet, to get you thinking about some of these issues on a different level. But understand, of course, the session is limited in scope and time, certainly. So we'll do our best to get through these materials, but no doubt, you'll have some follow-up questions as you move forward. So just briefly here, and some of you may already have a keen understanding of IP. Some of you may have attended some of the other Elevate IP seminars under the Navigating IP series. Briefly, when we talk about IP, we're talking about creations of the mind. These are intangible works, creations such as inventions, literary works, books, for example, artistic works, names and logos, product designs, packaging designs, other sorts of ornamentation applied to a product. We will walk through the categories of IP very briefly. But again, these are intangible assets that may be legally protected, separate and apart from rights in physical assets. So next slide here, this is an important slide. I think it provides a really good overview of the categories of IP. The scope of protection under the different categories is jurisdictional in nature. So for example, if you acquire a patent or trademark in Canada, unless you pursue the same rights in other jurisdictions, in the US, for example, you will not have any rights in those jurisdictions. So it's important, especially when you're thinking about growing your business on a global scale, that you're mindful of the jurisdictional nature of IP rights, and the need to protect certain IP in key jurisdictions of interest in order to have enforceable rights in those jurisdictions. So just briefly, if we go through the categories, patents, of course, cover inventions. These are new and useful products, processes, systems, improvements, etc. The scope of protection is 20 years from the first filing date. So that's your all-important monopoly, the 20-year monopoly to practice your invention exclusively, to prevent others from practicing the same invention. Trademark rights, these are branding rights in effect. They persist in perpetuity, and they can actually subsist with or without registration, but there are key benefits to registering. So Coca-Cola, McDonald's, any brand out there, they're not going to lose their rights. Their rights will not be extinguished after any point in time. As long as you're continuing to use your brands, you will have rights in those brands. Copyright, again, categories of works are protected by copyright. Literary works, dramatic works, artistic, musical works. The term of protection for copyright is, in Canada now, it's the life of the author plus 70 years. So that means you take the author's life and then at the date of their death, you tack on 70 years. And then their estate would have presumably control, or another assignee or licensee of the works and any royalties that would be generated. So keep in mind, once a work is past the term of copyright, it's now in the public domain. And so, like works of Shakespeare, for example, you don't have to pay a royalty or license fee to Shakespeare's estate when you put on a commercial performance of one of his plays. And then there are a number of songs, older songs, for example, that are now in the public domain. So they're not royalty bearing. Industrial designs, these are also known as design patents in the US, and these generally cover a product shape or product packaging shape or pattern or other ornamentation applied to a product or its packaging. Probably the most famous industrial design or design patent is the Coca-Cola bottle, one of the earlier design patents. And then finally trade secrets. So effectively, we're looking at categories of confidential information that gives a business a competitive advantage by not being known. So probably the most famous trade secret is the Coca-Cola formula. So the effective recipe for Coke. And in their Atlanta headquarters, they have a big safe. It looks like a bank safe. They apparently have the complete formula in that safe. They take pains to ensure that, on their manufacturing floor, that, individual personnel only have certain information about the formula, but not the complete formula. And an important point to note, and this issue does come up in the patent realm a lot, is this pull between patents and trade secrets. So, for example, if Coke sought to patent their formula way back when, well, they would have had to disclose the formula in a patent application, and then after 20 years, they would have lost their monopoly. So practically, of course, it would make sense, and did make sense for Coca-Cola to maintain the formula as a trade secret. And again, that formula, then that secret persists in perpetuity as long as it's never publicly disclosed. So also briefly, I wanted to just walk through a couple examples showing you this notion of layered IP rights. When clients come to us with an invention proposal, something they want to patent, we then look at, again, this notion of layered IP. So if you're coming to market with a particular product or good or service, a software application, what have you, you're typically looking at a set of layered IP rights. Whether you pursue protection under those different categories is something to be determined in each case. But in the case of a weight loss drug in this example, you can have patents covering the product, the composition, formulation, dosage form, a manufacturing process. Of course, you have branding rights associated with the drug. Industrial design. I mean, you could apply a design patent to the shape of the drug, or sorry, the pills or tablets. There may be some unique packaging, and then some of the more specific formulations and business and marketing information, could be protected by trade secret. And then a second example, this is a software application, in this case, a music streaming platform. In the patent realm, and few people, you probably think of a streaming platform and think, well, they're all the same, and what's the IP there? But a company like Spotify, they have well over 1,000 patents now in their portfolio around the globe, and they're protecting, certain methods and processes, software architectures related to the application. Of course, the general streaming technologies, hardware, software integrations, song recommendation engines. They even have patents covering systems for creating music compilations and copyright infringement or plagiarism detectors. The user interfaces on the application are protectable by industrial design or design patent. Certain key algorithms, know-how, and formulae would be protectable by trade secret. And then, of course, they have their branding rights under trademark. And copyright, again, there's layered rights here, but the source code technically is copyrightable. And then there'd be certain design elements that would, have layered protection through, any combination for perhaps of copyright, trademark, and industrial design. So the importance of IP to a business, and we'll talk more about this in the upcoming slides, but In general terms, IP can represent a very significant asset of a business. It's not a hard and fast rule. Certainly, there's some businesses with certain IP where the IP is of very little value to the business and does not materially impact the the business's ability to generate revenues. In other cases, the IP portfolio, the patents that a business holds may be the bulk of the assets and the bulk of the revenue generation that the business is able to obtain, may be tied directly to their IP, to patents in particular. There are statistics showing that the value of the average issued and unlitigated U.S. patent is approximately $400,000. Again, that's in a vacuum. There's some patents that are worth very little, some patents that are worth nothing, perhaps, other patents that are worth many millions, tens, or even hundreds of millions of dollars. Just by way of example, these are some notable patent license and assignments or sale transactions which show general value of a patent portfolio. So we have AOL's patent sale to Microsoft, which averaged $1 million per patent. BlackBerry last year sold its non-core patents for upwards of $900 million. IBM is estimated to generate over $1 billion a year by licensing its patents, so it still owns the patents, but it's generating significant license fees per annum. So the notion of IP as a value generator, we're looking at commercialization and protection, or protection and commercialization strategies to help derive value for your business. And clearly, we've seen, across a number of decades, a real shift in the economy from a tangibles, consumer goods or products-based economy to an intangibles economy. Software, subscription services, business methods. If you look at the most valuable companies in the world, that they're for the most part holding intangible assets, right? IP in particular. So the Apples, Googles of the world, Meta, Amazon, you can think of many other large multinational companies that fall into that intangible sphere. The cloud computing industry, that's all intangibles, and they're swiftly approaching $1 trillion in market size. 2 decades ago, the cloud computing industry wasn't really even a thing. It was in its infancy. Of course, the market for AI technologies is also now in its infancy, but it's growing by leaps and bounds, and of course, it will be worth many trillions of dollars in years to come. There's a general acceptance that in an intangibles economy, companies that hold registered IP, including patents in particular, are consistently more valuable than those that do not. And of course, the value of a particular business's IP will depend heavily on a range of factors, market conditions, the competitive landscape you're in, any revenues you're able to accrue directly from your protected IP, including your patents. And so, when we look at the benefits of having a robust IP protection strategy, a lot of these factors are interrelated. But you can have direct impact on value by generating revenues. You can also have more indirect impact in terms of a general enhancement of valuation just by having a strong patent portfolio. Certainly, you can make a patent or set of patents can attract investment, higher valuations on those investments. You can build a product or service moat, some exclusivity by holding patents, and ultimately reduce competition by keeping your competitors at bay, by preventing them from copying your ideas, your inventions. The notion that investors are more likely to be interested in projects where you do hold monopoly or prospective monopoly protection via IP protection via patents and pending patent applications certainly holds true. There's no question, one of the first questions investors or prospective investors will ask is, what do you have that's proprietary? What does your patent portfolio look like? How can we gain a competitive edge in the marketplace by holding monopoly rights? It can also help you with any financings, loans that you're looking to pursue, where you're setting out or holding your patents out as collateral. There are different trade statistics out there, looking at startups who hold patents versus those that don't. I've seen some statistics that show that, all things being equal, a startup that holds patents can be valued 2 times higher than a similar startup without patents. Of course, there's no one size fits all there, but the base notion holds that holding core IP, key IP, developing a patent portfolio or other IP portfolio will no doubt give you a competitive advantage in the marketplace, and make it more likely that you'll succeed. Certainly, it can make you more attractive as an acquisition target, not just in terms of the investments, but in terms of a party that might want to acquire your business. It can certainly help mitigate legal risks. So, if you're holding key IP, you're inevitably reducing the likelihood that you're going to run into an IP infringement dispute, which certainly can be costly and can potentially deter even the notion or general threat of litigation, can deter investors. Certainly, holding a strong IP portfolio enhances your credibility in the market. It shows a seriousness to your business, the fact that you have all your ducks in a row, that you've been thinking and been proactive about your pursuit of IP protection, signals to investors that you are a legitimate enterprise that is looking to obtain a strong foothold in your market. And of course, there's potential for spin-off opportunities, building offshoots to your primary technology, that can result in companies that you may spin out, which may enhance the value of the entire enterprise. There are many tech companies, including large multinationals, that have produced valuable spin-offs. So when we talk about commercializing your IP assets, I wanted to I guess say at the outset, there's certainly no one size fits all approach to commercialization. And of course, when we talk about commercialization, we're talking about effectively your go-to-market strategy. How are you going to exploit your IP to generate revenues for your business? And I will emphasize again, effective commercialization depends on an effective IP protection strategy. If you don't have the IP protection strategy in place, you could have material difficulty pursuing effective commercialization. Not in every case, but in many cases. If you don't take steps to protect your IP, you might be opening yourself up to material competition, where competitors can effectively trade on your IP because you didn't protect it in the first instance. Commercialization options, they are certainly varied and can include any combination of steps. So certainly you could decide to sell or assign or transfer your IP outright, let someone else commercialize it, but you're effectively selling your business or selling the IP assets of your business in exchange for like a lump sum financial payment. You can go it alone and commercialize the IP yourself, produce goods or services, build a team out to market and sell your goods or services directly to customers, you may engage with different third parties in order to achieve your commercialization goals. We're finding that more and more, it's difficult for a startup to go it alone. That doesn't mean that you should be, selling your IP or even licensing your IP, but there may be strategic partnerships, to help you tap into, businesses with certain resources to help support your business objectives. And then, of course, these engagements will inevitably need to be supported by legal agreements, with your strategic partners. You may enter into a joint venture where there's some additional co-development occurring. The whole concept here is this notion of symbiosis, right? So if you can suss out strategic partnerships, where both parties benefit, that can really help you move the needle. And again, no one size fits all here. In certain instances, it makes practical sense to actually, really go it alone and preserve, the control and preserve the sort of full value of the revenues that you're pursuing, without diluting them. Licensing, of course, so licensing takes many different forms, but effectively you're giving a third party permission to use your IP rights through a licensing agreement, and they're paying you a fees, a royalty fee, for example, in turn. So, license agreements include franchise agreements as well. So instances where, you may permit the licensee to manufacture, distribute, promote your goods or services. You may not have the capacity, or the distribution networks, and certainly within certain key markets, markets overseas, for example, you might not have the fundamentals in place to support, the growth that you're looking to achieve. So you may suss out a licensing play to permit a third party to license your IP to help propel, revenue growth in certain markets. And of course, you're receiving fees from the licensee, but the licensee is in turn receiving their own fees by exploiting, the IP rights that they've licensed from you. So protecting and commercializing your IP, this slide, just sets out a few questions that you should be considering when you're, starting to define a protection and commercialization strategy. Certainly, you should start by understanding, unpacking the IP that you've created. Consider the baskets of IP that you've created, under potential patents, trademarks, copyright, designs, trade secrets. You need to ensure that you have your ducks in a row from an assignment standpoint to ensure that, if you're a business, a company, a corporation, that the IP has been properly assigned by the inventors or authors. You need to consider, where you do business, where your prospective customers are located, how you're going to achieve manufacturing. Are you going to have to go overseas to do that? Many businesses, of course, will have no manufacturing component if you're not talking about, production of goods. You should look at, the competitive landscape. Who are your key competitors and how have they organized themselves? Do they have IP? Do they have patent portfolios in place? If you find that many or most or all of your competitors hold patents, then you certainly have to be mindful of how you can compete effectively without infringing their patent rights. And if all of your competitors hold patents and you do not, consider, does that put you at a competitive disadvantage? And of course, if you decide to proceed without pursuing patent protection or other IP protection, is it going to be easy for your competitors, some of whom may be, more well funded than you to duplicate your success, to trade on your ideas and whatever you brought to the market, to take market share away from you. And then in terms of monetizing your IP, we've talked generally about the need to develop a strong commercialization plan. What is the business model? Are you going to pursue subscription agreements for a certain software application that you've developed? Are you planning to license certain rights in your IP to others on an exclusive or non-exclusive basis? When you look at where your customers are located and you say, okay, well, we've got great opportunities in, say, Canada and the US, there may be an opportunity in Europe, in Japan, wherever. But you might decide that you don't have the resources or the expertise to pursue some of those overseas markets. So we do see cases where certain clients will be more likely to pursue licensing and strategic partner type arrangements with third parties in jurisdictions outside of North America. So IP protection best practices, and we've covered some of this in the preceding slide. I think at the outset, for many businesses, many startups, you should be considering a form of IP audit to basically look at the IP that you developed, define a roadmap to say, okay, well, we've developed, solution X or invention X, we've got inventions Y and Z in the pipeline. Consider, certainly your IP protection strategy, but also consider how you're going to effectively commercialize the IP that you are potentially protecting. The worst case scenario would be, you don't want to fall into pursuing IP protection and potentially obtaining good patents if you don't have, if you're not organized to effectively commercialize your IP. There are many businesses out there who hold patents that are very little value because they haven't been able to, the businesses have not been able to effectively commercialize their IP. And so I really want to emphasize that your IP protection strategy needs to go hand in hand with your commercialization plan. If you're pursuing patents without any real idea of how you're going to monetize those patents, then you're effectively putting good money into an effort that is not as likely to bear fruit. Protecting confidential information and know-how through confidentiality and non-disclosure agreements. This is very much key. Some of you may know this, but you're going to be limited in terms of your pursuit of patents in most jurisdictions around the world if you have already publicly disclosed your invention. So we've had some clients come to us and or prospective clients, and they say, oh, I've been at this for a decade and we finally got some traction, so now with our customers, so now we want to pursue patent protection. And unfortunately, they're out of time. There's a 1-year grace period that applies in Canada and the US. There are other grace periods applicable in some other jurisdictions around the globe, but for the most part, once you publicly disclosed your invention, in the US, once you sold or offered to sell your invention, you can be stopped from pursuing patent protection. And so, before you think about, attending a trade show or a pitch competition or a, putting something up on YouTube or on a website, you do have to be mindful of, I would advise you generally not to do that. Look at your IP protection strategy and develop a plan, and hopefully pursue certain filings before you take those steps, because the last thing you want to do is compromise your ability to obtain patents. So when should you seek patent protection? Again, we've covered some of this already, but you really want to hone in on, the value proposition. If you do obtain a patent or set of patents, a portfolio of patents, what does that mean for the prospective value of the company? Is it going to directly drive revenues? Is it going to enhance your ability to obtain outside investment to raise the value of the company organically with or without revenues? Again, looking at the competitive landscape, what your competitors have patented or not patented, looking at the technology, and if the technology can be easily designed around, then it will be harder to obtain strong patent rights. If an invention can be readily reverse engineered, then that's something where you would say, well, then we should be pursuing patent protection to prevent the illegal ready reverse engineering of the invention. If it's not possible to readily reverse engineer the invention, then you might consider an alternative, like a trade secret protection. In terms of whether the invention can be independently discovered, that's another consideration in the pull between patent and trademark trade secret protection. But again, there's no one size fits all approach here. So one specific concern, we touched on this earlier, is IP ownership. So you may not know this, but in Canada, you engage with an employee, an employee produces an invention or contributes to an invention, unless there's a written agreement to the contrary, or unless the employee was hired for the specific purpose of inventing, then the employee and not the employer will own the invention. So that's why it's very important when you're engaging with your employees, defining your employment agreement template, engaging with third parties, contractors, software developers, under a consulting agreement, professional services agreement, what have you, that you have clearly defined IP rights in favor of your business, your company. This is one of the first things that investors will look at. They need to ensure, will want to ensure that you have, effective, clean title to any of your IP. And just briefly, the patent filing process, patent protection is core to the funding that Elevate IP provides. You're going to want to leverage your IP portfolio to drive your commercialization efforts. You need to understand, generally, the filing process. You have options in terms of what you file and where you file it. We know that IP protection and patent protection, the regime is jurisdictional in scope. We often see, clients pursue provisional patent applications as a first step. This is a way to get your foot in the door with the patent office. You get that all-important filing date. Anyone who files after you then is second in line. And in a highly competitive industry, it's very important to establish that early filing date, because you never know who's filing what and when. And I'll show this on another slide, but basically, if you file a provisional application in the first instance, it does have to be robust. It does have to define the subject matter in detail, sufficient detail to support a future non-provisional or formal patent filing. But you effectively have 1 year from the provisional filing date to file your formal application. And then many clients who are pursuing patent rights on an international scale, they will elect to pursue a PCT filing under the Patent Cooperation Treaty as their formal filing. This is particularly beneficial for clients who need more time, more time to raise funds. They want to defer legal costs. They want to keep their options open as far as where they file around the globe. So if you file a PCT application, I think I'll just jump to this next slide. You gain an additional 18 months to make decisions about national filings. So this is a little confusing for people who have not been through the process. But if you file a provisional, day one, you have your direct national filings or your PCT filing at the 12-month mark. If you, instead of a direct national filing, say in Canada, the US, you pursue a PCT filing, that gives you 30 months a total from the provisional date to decide on your national filings. So there's no such thing as an international patent, unfortunately, but there is such a thing as an international filing. And just briefly, before we get into the licensing piece, trademark filing best practices, I'm not going to go through the examples on this slide, but I would just emphasize that you do need to be thinking globally. You do need to be thinking about, key markets and jurisdictions before you launch a business, before you launch a brand. If you're pursuing, a particular brand opportunity, selling goods or services in, say, Canada and the US, and then, years later you say, well, we want to launch in Europe, and you find out that there are competing marks already registered or used in Europe, then you might be forced to define, a new brand for the European market, which is not necessarily, a preferred approach, would not be a preferred approach. So IP licensing, we've talked about licensing, somewhat in some of the earlier materials. Effectively, you're leasing your IP rights to a third party, to a licensee, in exchange for a fee. The third party will maintain ownership, or sorry, the IP owner, the licensor will maintain ownership. They're simply granting rights, use rights, commercialization rights in certain instances to a third party. And the notion here, again, it's that whole idea of symbiosis. If you think you've got the North American market covered and you can produce and sell your goods or services in that market, but let's say you say, well, the South Korean market is foreign to us, we don't know how we can make inroads without partnering up with a third party, we might pursue a licensing arrangement in that jurisdiction for a particular length of time within a particular field of use to enable a third party to effectively, push commercialization efforts in that market. And in exchange, we'll get a royalty fee back from the licensee. Of course, you're going to want to paper up a license agreement. There's really no one-size-fits-all approach to licensing, and certainly the advice that we provide will differ depending on the circumstances, and certainly depending on whether we're acting for the licensor or the licensee. Pitfalls that you can run into in licensing IP, you really have to, I'll emphasize this again, the notion of the fact that there's really not a one-size-fits-all. And so, and also that you have to be mindful of how accurately you can extrapolate the license terms to project out to say, okay, well, if these are the terms in place, this is the royalty calculation, what does that mean for our bottom line? And what sorts of resources do we as the licensor have to put into the mix in order to help the licensee generate, the sales that they're promising us? I've seen some really bad license agreements over the years. And particularly in cases where clients are entering into an exclusive arrangement with a third party, with a licensee, exclusive arrangements where the licensor is effectively giving up their right to commercialize the IP can be very problematic. And so you have to look at, the granting provisions, whether the agreement is exclusive or not, or proposed as exclusive, what are the termination rights if things don't work out as planned. In a perfect world, you're using a license agreement to create a new income stream that you wouldn't otherwise be able to create or to create efficiently. You're tapping into new markets that might be hard to enter into on your own. And of course, you're not having to build out the infrastructure that might be required to service a particular region or market. So some of the pros and cons, and some of this we've discussed already, and I'm mindful of the time, so I do want to leave some time for questions. But again, there can be many benefits to pursuing licensing arrangements. There can also be some key drawbacks, and that notion of extrapolation very much holds true. Like what if the licensee is projecting sales targets and you're defining a royalty based on the expected sales, well, consider whether those sales are likely achievable. How are you holding the licensee to account to meet their sales obligations? If you're using a licensee to break into a particular market, and if the licensee is having to put significant resources into that effort, they may well, demand that you set a lower royalty rate. There are many nuanced provisions when you're looking at the royalty calculation, the formula. We will look at ways to enhance, if we're acting for the licensor, to enhance the arrangement for them, so that maybe they're getting license fees up front, a minimum annual royalty fee that's payable month to month or every quarter. You're looking at setting particular performance obligations on the licensee to ensure that they're putting sufficient resources, time and effort, materials, and monies into the arrangement to push the sales and revenues that they're looking to achieve. If you're defining a license as an exclusive license where you don't have the right to practice the IP or exploit IP rights in a particular territory or market or a particular field of use, then you need to ensure that you have very stringent and enforceable requirements, responsibilities, or obligations on the licensee. These sorts of engagements can sort of be a minefield if you're not careful. So you really have to be, cognizant of the specific engagement that you're purporting to enter into. Look at who the licensee is. What is their track record of success? What resources are they bringing to the table? And don't assume that the royalty calculation is a one size fits all. I mean, you see, for consumer goods, often, ranges from 2 to 10% of sales as a royalty fee. But what does that mean in specific context? And does that make sense in view of your industry? And again, at the end of the day, you want to ensure that there's going to be a symbiosis. Each party is going to benefit from the engagement. But if you enter into a bad license agreement and you don't have an easy way to get out of that agreement, then you can really, the licensor can shoot themselves in the foot. I'll break now for questions.
Yeah, we have a question from Bradford. You can unmute and ask your question.
Okay, first of all, thank you very much. It's very much appreciated. Very, very informative, David. And two-part question here. There's a 1-year grace period on what is publicly available within the IP that you put out. I'm guessing that's on website, published, or open source. The second part to that question would be anything that you didn't make publicly available then would not be under that grace period. Is that correct?
Yeah. So the grace period rules, they differ even between Canada and the US. In Canada, we're talking about an enabling disclosure, as the trigger. In the US, we're talking about there's an on-sale bar. So if you're selling or offering to sell the invention, if you sell or if you have a subscription agreement in place for your software, but no real enabling disclosure, you're still barred from that 1 year grace period still applies or still starts to run. So you do have to be like, there is a distinction certainly between, putting some general information out on into the public domain to say, well, we've got a solution to a particular problem. In theory, that's not an enabling disclosure and the clock would not start to run. But otherwise, I think you have to be very careful. You have to err on the side of caution, right? To ensure that if you're in doubt about a particular disclosure, certainly talk to your lawyer to see if they're, what the law particularly says about your specific scenario. But otherwise, if you have not engaged in any, potential disclosures, then preferably you're not going to do anything, to disrupt that until you've defined your patent filing strategy.
Right, but anything, I guess the question there is anything that's already publicly available. Say we open source something already, we'd have a year grace period from when it was open sourced, because it's publicly available.
In theory, yeah.
No, I know what you mean. Everything's a little bit more complicated, but in theory, and definitely, let's see, like it's specific.
There are different rules applicable in different countries. And as I said, most jurisdictions around the globe are absolute novelty jurisdictions, which means as soon as you make that initial disclosure, you're out of time to patent.
Right.
But you really have to look at the specific, fact situation that you're dealing with to make an assessment.
Right, and the word publicly available, obviously NDAs, NDCAs, that essentially would make it not public because you're sharing it with parties that.
Yeah, if you're making a disclosure under an NDA signed between the parties, or otherwise, even without an NDA, if the circumstances indicate that the disclosure is intended to be confidential in nature, then there will be no disclosure.
Excellent. No, that's fantastic, David. That's exactly the answers to the questions. You've been fantastic, and thank you as well, Rochelle. I don't want to take up everybody's time, so thank you. Perfect.
Sure, we just have a minute here left, but feel free to please stay on for your additional questions. So I'll go through the list here on the chat. So are there specific industries where license?
Sorry, you cut out on my end.
Oh, sorry. Did you hear that? Okay, I'll repeat the question. So it said, are there specific industries where licensing is recommended or not, or is it totally circumstance dependent?
I think it is circumstance dependent, certainly. And it depends on the resources that the startup is bringing to the table, at the outset. And as I said, you don't have to license rights away in order, like if you're pairing up with a manufacturer overseas, you're not licensing the IP to them per se. I mean, you're granting them a manufacturing license, but they're not then commercializing for you and selling for you, right? If you're engaging with a licensee under an exclusive license, could be non-exclusive as well, but under exclusive license where they're actually taking the reins, taking the IP and running with it, that's there's a clear distinction there. I think you do have to look at, the capabilities of your business, right? Like if you're so overwhelmed and you don't have the financial resources to support, if you're planning a global sort of play for your goods or services, it may well make sense to enter to pursue a licensing arrangement, but you're giving something up, right? Like you're taking these, yes, but the licensee is taking, in certain circumstances, material monies, because they're the party that is directly interfacing with the clients and taking, the full revenues before they revert a royalty payment to you. And I mean, I've seen clients get caught up where, they go into an engagement in good faith and they think, oh, this licensee is great, they're saying all the right things, we really trust them, and then you look at the agreement and you say, this is not good, this is one-sided, this may not end well. So I think, again, you have to be very careful when you look at setting up a licensing arrangement. And again, in certain industries, I mean, the specifics, within a trade, the specific, like if competitors are engaged routinely in licensing IP within a particular industry, that may well suggest that you should be considering a licensing play. And as I said, you might also consider a licensing play, not on the whole necessarily, but in certain jurisdictions and certain fields of use. So you say, we're going to give exclusivity to this third party in parts of Asia because we don't have the person power to sort of penetrate that market ourselves.
Great. We'll do another question here. Are there disadvantages Canadian companies have when licensing with US entities or licensing into the US market? Any general recommendations here?
So your agreement will define governing law and jurisdiction. And so for certain licensees, larger, licensees, they may push U.S. courts and U.S. law as the governing law and jurisdiction. And then you're beholden to the U.S. laws as they apply to that agreement. You have to be mindful of, any competitive advantage that you might give up by offering a license, right? So if you, and this is sort of across the board consideration that's not dependent on a particular jurisdiction, but you engage with a third party, you disclose particular confidential information to them. And this is an important point to note. I mean, you're not always licensing just a patent or patent rights, you're licensing trade secret rights or confidential information, disclosing confidential information. And then if the relationship between the licensor and the licensee falls apart, what can you do to sort of rein that in? Do you have a non-compete clause in the license agreement to prevent the licensee from competing against you in a space in your industry after the agreement is at an end? It's certainly, even if an agreement is governed by Canadian laws or Ontario laws in certain cases, that doesn't mean that the third party, will be easy to litigate against. They could challenge the jurisdiction. They could try to draw you into litigation in the U.S. They could try to exert whatever financial clout they have against you. So, I wouldn't say there's specifically an issue with a U.S. licensee engaging with a Canadian licensor, but you do have to have your guard up to a degree, and I've seen it, time and again where a license agreement is put forward that is either not fair or it's extremely one-sided in favor of one party or the other. And often you see in those situations the licensee or the licensor, whoever's drafted the agreement, they try to tell you, oh, well, this is sort of industry standard. And in my view, nothing is necessarily industry standard. You really have to look at your specific circumstances and make sure the deal makes sense, for your business. And on that point, this notion of extrapolation of projection is very important. You have to really keenly look at what the royalty means in real dollar value terms, as the license proceeds each, year to year.
So there's a couple questions on trademarks, but maybe we'll leave that for now. But there's
I can answer those too. I'm totally okay if you're okay with running
Sure,
over.
sure. Okay, so we did do also a trademark session, I think a month or two ago. So maybe we'll take the licensing question first. How do you control the licensees' internal, and how would you know if they actually sold your product or not?
Yeah, you have to ensure you define strong audit rights. And I, I guess near the tail end of this presentation, we sort of ran out of time to really delve into licensing issues, but they or like the particulars of a license agreement, but particular terms. But again, we could spend an hour or two just going through the mechanics of a license agreement and particular terms of interest and how to manage those. On that point, if you're defining royalties to be paid out month to month or every quarter, you do need to have a strong audit right, to ensure that you have the ability to assess the sales data that the licensee is putting forward. You can structure the arrangement so that you take some risk off the table by defining a minimum annual or minimum quarterly or monthly royalty payment that the licensee has to pay out, and you could draw down from that too, right? So as they achieve their sales, they're drawing against that minimum payment, and then if they exceed that their minimum sales targets, then they're paying additional royalties to you. But at least you're getting monies up front. That's generally a preferred approach. Also setting a minimum payment that is not tied to any sales, to say, well, just as by virtue of having the license and in view of, maybe some of the resources, the training, time and materials that the licensor will be putting forward to help the licensee, you should look at maybe defining, okay, well, we want to take X amount as a guaranteed payment. It is not contingent on the licensee achieving sales targets. That's a separate royalty. But again, you do, and even too, in terms of setting the royalty at the sales. Well, are the sales the gross revenues, or the net revenues, and what goes into that calculation? Of course, you can whittle down your gross sales materially by including a whole host of expenses in that net calculation, and then whittle down the royalty amount accordingly. So you have to have a keen understanding of the mechanics of the royalty that's proposed, and consider whether it makes sense to vary that to make it more fair or to make it more favorable to you as a licensor.
Okay, great. Maybe we'll take one more on trademarks. So can you please speak about the logistics and constraints related to trademarks, time constraints, use requirements, etc., for logos and or brand names?
Yeah, so trademarks, again, jurisdictional, like all forms of IP. So the rules that apply in Canada will be different from the rules that apply in the US and Europe and elsewhere. Generally, you have to have use and you have to establish use and have continued use of your brand, logo, name, slogan, whatever it is, in order to have rights that are enforceable against third parties. In Canada, you can actually register a trademark without the need to prove use, but in the US, you cannot do that. You have to prove use before you register. There is a mechanism that allows you to piggyback off of your Canadian filing, to actually register in the US without the need to prove use, but that application in the US would then be vulnerable, or the resulting registration would be vulnerable to a cancellation proceeding if you weren't using the mark. Use effectively requires, we're talking about goods and services, that you have in trade, or in the ordinary course of trade, you have sales. You can't have manufactured, oh, I sold a product to my cousin and it's an artificial sale and it's not in the ordinary course. You have to have, you have to track to show sales in the ordinary course of your business to non-arm's length parties, to arm's length parties. You don't have to generate any particular volume of sales. In theory, you could have a handful of sales, and that would be sufficient to establish use in your market. And I mentioned this previously. You should be looking at, if you can try to project out to say, well, we want to be in Canada and the US with our brand initially, and then maybe Europe is the next step after that. Well, you should probably then be clearing your marks, or your core mark, in the European market, even before you decide to enter that market, just to ensure that you're not going to be, surprised that a third party has prior rights ahead of you in that.
Excellent. Thank you very much, David. Are you okay if anyone else who has questions sends them your way through email?
Oh, of course. Yeah, absolutely. Happy to help.
Excellent. Thanks so much, everyone, for attending. Please ensure you do fill out the survey that will be sent to you through email. That would really help us in kind of envisioning what the future of our education programs look like and offerings. So thank you so much for attending and hope you have a wonderful day. Thanks again, David. You can stay on for a
Thanks,
little
everyone.
bit. We'll say goodbye.